Yeah, sure, we can get started now. So, welcome everyone to the IvyConnect session. So, for those of you who do not know what IvyCamp is, so you would have heard of IvyCamp Ventures. We just closed our third fund yesterday. So, we are a leading VC fund, homegrown, uh, to be precise, and we mostly invest in seed, pre-seed and beyond stage startups. Check size starting from 2 crores to 50 crores. Some of our notable investments are Bluestone, Biryani by Kilo, Expertrons, Miko, um, and we are looking forward to invest in more. So one of the initiative which we have is called as IvyCamp. And what we do at IvyCamp is we engage actively with a lot of institutes, e-cells, corporates, incubators, and we work very closely with startups. We help them in funding, and then we also help them in mentoring sessions. Yeah. So as a part of that, we do a program called as IvyConnect. We run it on a monthly basis. So this is our third for this year, and we have our speaker Arjun Bala, who is the founder of Metayage. So he'll be talking about the IPR. So over to you, Arjun. You can start off with a small introduction, and then we can take the session ahead. Also, we would like to keep the session as interactive as possible. So please put on your questions in the chat and we'll take it one by one. Also, you can also unmute and ask the questions in between. So we can do that. Okay. Thank you.
Yeah, thanks, Rupali. I'd like to know a little bit about the participants. Like, how many of you are maybe looking to become entrepreneurs, or how many of you are already entrepreneurs running a startup or your plan? If you could raise your hands, you can do that on the reaction button. So I can see Geetu has given a thumbs up. Yeah. So any research scholars? Okay, Mayur as well as an entrepreneur. Great. Um, Adnan and Anshuman. Okay, great. So any other, like, you have research scholars or anyone doing research? Yes, few more entrepreneurs. Okay, I see. That's great. Okay, there are quite a few entrepreneurs here. So I'll just introduce myself and I'll get started. Yes, Akhilesh, good to know that you're a research scholar. You can put your messages in the chat. It'll be helpful. So I'm going to first, my name is Arjun Bala. I'm a patent attorney and I'm the founder of Metayage, which is an intellectual property firm. We've been focused on working with tech startups, and we also work closely with a few investors. And we also work with research institutions and help them to protect their valuable innovation. So this session today is going to be about protecting your innovation using different forms of intellectual property rights. So I'm an alumnus of IIT Bombay, by the way, and I've been a patent attorney for the last 20 years. Our firm has got over 350 patents registered in India. So I'm going to share my screen. Rupali, I need your permission for that. If you
Yeah,
could make me a host.
1 second, sure. Yeah. Please try now.
Yeah, good to know that there's few more research scholars here. Great. Welcome to the session. Actually, you also put in some topics of research which are of interest to you. That might also help. Yeah.
Share your
So,
screen now.
Rupali, I'm going to
Yeah.
I'm going to share my screen, and please let me know if the slide is changing. Otherwise, I'll have to share again. Are you able to see a full screen?
Yeah, we can see the full screen.
But the slide is not changing, right? Okay.
No.
Yes.
Just give me a moment. I'll have to put it in presentation mode and share it. Yeah. Okay.
Um, we can see the screen.
Still not.
Try. Still not able
Still
to.
the
Yeah.
slide is not changing.
No, slide is not changing.
Okay, it's changing now, right?
Yeah, it is changing now. we can see.
Okay, great. Okay, we'll get started then. So the first question I have for all of you, especially the entrepreneurs and the research scholars over here. So you all are you have some some technology that you're working on. You're doing some research, or you have some product, right? So how do you measure the value of your product or your research or of your business? So what really is the value that you're creating? That's the first question. The second question is like, okay, you are creating something of value to your customer or your target audience, but who owns the value that you're creating? Now, you might say it's you yourself, right? But as we'll discover in this session, it's not such an obvious answer. Okay, so I'm sure a lot of you as entrepreneurs are looking to generate wealth, right? How many of you want to generate wealth from your venture? So you can maybe raise your hand or you can do a thumbs up, yeah? We have Rupali here who's from a venture capital firm, so I'm sure they're very interested in generating wealth. So okay, so what is really wealth, right? How do you generate wealth? So we have a I would put it in a very simple way. It's a value multiplied by leverage. So value is what you deliver to your customers, your stakeholders, and so on, and then leverage is the control that you have over exploiting that value. Because often what you'll find is that there are people who create value and there are others who come and exploit that value commercially. So often the people who are actually creating the value don't end up leveraging it. So that's why it's very important. If you want to generate wealth, it's not just enough to create value, but also to have leverage over the value that you create. And how do you have leverage or control? It comes with ownership, right? So if you own something, you have control, you have leverage over what to do with it. Now you can do anything. Like if you have, for example, you own some asset, right? You can, you can make money from it in different ways, or you can even give it away. You can give it away for free, but that is a choice only if you own it. If you don't own it anyway, you can't do anything about it. A lot of you might be familiar with Robert Kiyosaki and the various books that he's written, and I've taken this quadrant from him. So he says broadly there are two ways of generating wealth or income. So the first one is active income, and then the other is passive income. So active income is where you have to keep working for money. The moment you stop working, you lose your income. And passive income is where money is working for you. So if you're an entrepreneur, you have typically a team of people who are working for you and who are generating income for your business. You may own assets which are also generating income and which are appreciating and hence generating income and wealth for you. Of course, the best is to be an investor, right? Because these people, once they make a good decision on an investment, then they can even go and play golf and the money is just constantly growing, right? So that's the best. So that these are different forms of active and passive income. So why am I talking about this here? Because for those people who are interested in generating wealth, especially entrepreneurs, you have to know that the best way to generate passive income is by building assets, right? So Robert Kiyosaki says an asset is something that puts money in your pocket. So the more assets you generate, the more passive income you can generate. But then you might say, okay, I don't have that much capital to go and acquire assets, right? So one way in which you can generate assets is through your intellect, and you can generate intellectual assets, which will then generate passive income for you. And that's what this session is going to be about. So, but if you have intellectual capital, it is converted into an asset that you own only when it is protected and it is legally owned in your name, right? You have documentation to prove that you are the owner. So, how do you do that? By registering intellectual property rights. So, what is intellectual property or IP? We hear this phrase being used. So, at a very high level, intellectual property is something that is created as a result of intellectual effort. and which is intangible, which means it can't be touched, it can't be seen in the same way that physical assets can be, right? But still, it has great value, and that is why it's an asset. So broadly, intellectual property could be inventions, creative expression, goodwill, and know-how. These are the different forms of intellectual property, and they are protected using different forms of intellectual property rights. So, for example, inventions, which are typically focused on a certain function or a result that you're trying to accomplish, which is superior to existing technology. So, such products or processes are protected through patent rights, and works of creative expression are protected through copyrights as long as they're original, they're not copied from someone else. And then we have the external appearance of physical articles, which is protected through industrial designs. And we have uh, brand names, graphical representations, logos, protected through trademarks, which is essentially a way of protecting the goodwill that a business generates. And finally, we have confidential information, which is protected through trade secrets. So we'll start going through each of these forms of IPRs one at a time. So let's start with trademarks. So what is a trademark? So it could be a word like, for example, Toyota. It could be a symbol like the Mercedes Benz symbol. It could be a slogan like the Nike slogan, "Just do it." It could even be a packaging design, provided the design of the packaging is associated with the company that has created that and which is selling a product with that packaging design. So broadly, it's a graphical representation, or it's a way that it can be sensed, and this representation, it identifies the source of the product or service. So when potential customer, consumer, user, when they see that mark, right, which could be a name or a symbol, slogan, logo, and so on. So then they know which company has offered that product or service because they associate that representation with that company, right? So it identifies the source of the product or service and it distinguishes it from others in the marketplace. So when you see cars having different symbols on them, you know which car, is a Volkswagen, you know which one is a Mercedes, you know which one is a Skoda, and so on. Just by looking at the symbol, yeah, you can also read if the name of the company is written on. So, what is the purpose of a trademark? It indicates a source or origin, like I mentioned. It assures the consumers of the quality of goods which have the mark, and it creates goodwill. So, what is goodwill? Goodwill is basically reputation. So, when a consumer sees that mark, then they associate a certain reputation that the company has built with the product or the service bearing the mark, and they are likely to buy that particular product which has the mark, right? And if they have a positive goodwill, positive association with that company, that brand, then they are more likely to even pay a premium for the product or service compared to another product or service which doesn't have the brand, right? So that is what goodwill is. Okay, so let's say you have a trademark and you want to protect it, right? You want to register your trademark. So, what are the criteria that you need to satisfy to get a registered trademark? So, broadly, there are two criteria. One is called absolute grounds, and the other is called relative grounds. So, let's look at what is absolute grounds, right? Absolute grounds means that the mark that you want to register, it should not be generic or descriptive. The more generic or the more descriptive your mark is, the more difficult it is to register it as a trademark. And the more arbitrary or suggestive, or I mean, more fanciful your mark is, the more unique or distinctive it is, the easier it is to protect it, right? So let's look at some examples. Say if you start a company which cleans carpets and you call it the carpet cleaning company, right? So that pretty much describes what the company's services or products are about, right? So you can't really register that as a trademark because if you do that, then you can stop anybody who cleans carpets from saying that they are a company that cleans carpets and hence a carpet cleaning company, right? So that is why the trademark office would not want to allow such marks to be registered. So let's look at something, in between, which is like Burger King. So whereas Burger King has the burger and the product that they sell is a burger. So and of course, they seem to be suggesting that Burger King's burgers are the king of burgers. So they're suggesting something, but they're not literally like describing it. So they're not saying the king of burgers or the best burgers, right? They're just saying Burger King. So it's not directly describing the mark, but it is suggesting something. So it's kind of in between. So those can be registered under certain conditions, but they're not so easy to register. The marks that are most unique with reference to the goods or services that you are applying for registration, those are the ones which are most likely to be registered. Okay, so I'm going to quickly go on with the session because we have limited time. But if you do have any questions on trademarks, you can post them on the chat. We'll come back to them. Okay, now I'm moving to copyrights. So copyrights, like I mentioned, they protect creative forms of expression. So when you have some sort of original ideas, creative ideas, and you uh, put them like you transfer them to a particular tangible format, right? Which could be words in the form of a literary work, like for example, a book that you write or a paper that you publish, an article that you write, and so on. It could be a dramatic work, a drama, a play. It could be musical, like a musical composition. It could be a work of art, like a painting or a sculpture. It could be a video recording, which should be a film. It could be a sound recording, right? So all these are forms of uh, tangible media on which we represent creative works, right? Even software it can be copyrighted when it is written in the form of code. So what copyright is basically, it's a bundle of rights, and the most important thing is the right to make copies. So person other than the copyright owner cannot make copies of the work. Work could be a book, a movie, or a software program, and so on, right? So, but it's not just restricted to making copies, like even translations, adaptations, storage of the work, and performance of the work is also restricted to the copyright owner. So they can stop other people from doing any of these things without their permission. So you might ask like how long is this copyright for, right? So copyright is really long and hence it is very powerful. For example, if an author has written a book or they have composed a song or they've written some lyrics, right? So then even after the author's death, 60 years after that, the heirs of the author can continue to own the copyright and they can continue to make money from the royalties that they'll get from the licensing of the copyright. So that is how powerful it is. So this is what I meant when I was saying that you can generate passive income. So imagine like you did something once and throughout your lifetime you're earning money from it and your heirs are also earning money for 60 years after your death. So that's a pretty powerful asset, right? So that's something that you can do with copyrights. Um, Registration is not really a mandatory requirement for copyrights, but if you want to sue somebody for infringing your copyright, then it's important for you to register your copyright. There are some exceptions to copyright. So especially, for example, if you are, making copies of a work for the purpose of academic, non-commercial use, research, criticism, or review, then, depending on the country's laws, they do allow permission. It's not considered an infringement of copyright. So you might ask like who owns the copyright? So the copyright is owned by the author, okay, by default. So, but what happens if the author is working for a company and if the employee's job profile requires them to create that work? So, for example, if you're a graphic designer, right, or you're a software programmer, you work for a company, right? and the company has got an employment agreement executed with you. And one of the clauses in that agreement says that whatever work you do, like whether it's software programming or it's creating designs and so on, the IP rights for that belongs to the company, right? So then the company would own that, the copyrights on your work. But what if you're a consultant, right? You're not an employee. So then it depends. It depends on the contract that is signed between the contractor and the company, right? So if there is no such term in that contract which talks about IP ownership, then by default, the consultant is the owner of the IP. So, like, for example, if you're starting a business or if an investor is looking to invest in your business, right? So, a lot of times you'll find startups pitching to investors, and one of the questions that they might ask the startup is like, okay, you claim you have this unique proprietary asset or whatever it is that something that you have created and that something that you yourself own legally, or is it somebody else's and you're just using it, and what are the terms of the agreement between you and the owner of that asset, right? So that makes a huge difference because it means that if that person who owns that copyright or that IP, if they decide to take you out from being a licensee, then you automatically lose all your rights to use that work. So that greatly affects your ability to make money from it, right? So just keep in mind, but the essence of this slide is that if you have created a work and somebody else wants to own that work, they can own it only by having a written agreement with the author. There's no other way. You can't just say, okay, I'm going to give you the right. So there's a verbal discussion that happened between you both. So I'm the owner, right? No, it doesn't work like that. It has to be in writing. So few limitations of copyrights, because we talk about other forms of IP as well, IP rights as well, right? So you can't really copyright an idea. Copyrights only protect expression in certain forms, like I said, literary works, sound recordings and so on, right? So, and that too, it protects them from making copies and performing them and so on, right? Now, if somebody looks at, there are two people who have a work that is very similar to each other, right? And if the second person has created their work without looking at the first person's work and without trying to copy it, right? They have done it independently. Then they are not infringing the first person's copyrights. So copyright is literally infringed only when someone either makes a actual copy of your work or they have tried to copy your work by having lots of similarities with your work, right? So you have to prove that the other person actually looked at your work and copied it, or they have made a copy of your work. Otherwise, it's if they did it independently, it's not copyright infringement. So you see, there are certain limitations of what copyright protects. And the requirement for copyright protection is originality. So originality is again a very low threshold. What it means is that
Everyone, please keep yourself on mute. Romit, I can see that you're on mute. It's disturbing. Please keep yourself on mute.
thank you. So
Yes,
as
thank
long
you.
as your work is not copied,
One second, I'll just try muting him. I can't see him. Yeah.
yes. So I was saying that as long as the work is not copied from someone, it's done independently, then you can actually protect it with a copyright. So it doesn't require a great amount of creativity to register your copyright or to protect it. So my screen seems to okay. So I'll now move to design registrations. So keep the questions coming in the chat. Uh, as you can see, there are some images of products there on the slide. Uh, the shape, the surface ornamentation, the look and feel of the article can be protected through design registrations. So you can see, for example, there are phones which have certain curves, certain shape, edges, and so on. So that is a design aspect which can be protected through a design registration. You have watches which have different types of engravings and carvings, and uh, so that can be protected in jewelry as well. You have the Crocs which have a unique shape and external appearance, right? And different guitars and even the Apple iPod and so on. So these things can be protected through design registrations. So in the US, they're called design patents. In India, they're called design registrations. So, like I said, it protects only these external features, and as they're judged by the eye. So just the way something looks, it doesn't protect how it works. So again, designs like trademarks are specific to a class in which they are registered. So you have different types of goods and you have different classes for them. So when you apply for a design registration, or even if you apply for a trademark, you've got to mention which class you're applying in. So there could be a class for, say, electronics. There could be a class for electric vehicles, right? So there are different for vehicles, and then, so depending on that, you would select the class to apply for that trademark. And similarly, even in design, there are more specific classes, right? The term of a design is only for 10 years, but you can extend it by another 5 years by paying a renewal fee. And design is not so difficult to register. It's not so expensive also. Typically, it used to take like 6 months, but then now there are some backlogs in the Kolkata design office, so it may take longer than that. um, so the requirement is that your design should be new, which means that you should it should not be available in the public domain. So if you, for example, started putting up images of your product on your website or on the e-commerce website, before you applied for a design registration, it's already too late, because then your design is not new anymore. So you have to apply for a design registration before you put it in the public domain, and no aspect of construction or mechanism or principle can be registered through a design registration. So when you apply for a design registration, you've got to typically provide photographs of the different views, like the top view, front view, side view, perspective view, and so on. And you've got to mention what is the class, what is the article, what is the purpose of that, and you register it with reference to that particular class. Okay, now we move to trade secrets. So trade secrets is it's basically nothing but some information or some data, right? Which it provides the person who has access or who has created that information to a competitive advantage and is kept secret. So basically, it's any information which has got value and which is kept secret, right? So that is what is a trade secret. So it's basically confidential information. So how do you protect this? So far, there has been, no exclusive trade secret law in India. Just recently, now they're about to introduce it, which is great news. But the main way of protecting trade secrets is through contract law. So what that means is that you might be familiar with non-disclosure agreements. So when you are about to share some confidential information with another person outside of your organization, typically, right? Then you would get them to sign a non-disclosure agreement with you, so that they keep your trade secret information confidential, right? And it's very important that you let them know that it is a trade secret. So in some cases, you may take a practical decision to disclose certain information to someone else without signing a non-disclosure agreement. So, whereas this is not recommended from a legal perspective, there might be certain, other reasons why you are choosing to do so. But even when you share some information like that, it's very important to inform, to notify the recipient that this information is proprietary, it's confidential, it's not meant to be disclosed to anybody else, particularly without written consent. So you can put a, notification in the, for example, the email or the message that you're sending to them, so that they at least know that it is a trade secret, right? So many times companies they end up disclosing trade secrets inadvertently. So let me give you an example, right? So you might have heard that in the beginning, Apple went and they learned a lot of things from other companies. So Apple once went and they visited the premises of Xerox, and they got a chance to see different uh, areas of research that Xerox was working on. And one of the things that Xerox was working on was this user interface. And Apple copied it in their Mac, and even Windows copied it. So but because maybe those aspects were not protected by Xerox, and they were also not, disclosed to be trade secrets, there's no NDA signed, they were not able to stop these people from copying them. A more famous story is another, which you might have also heard of, is from the movie Social Network. So where the idea for Facebook was actually not exactly, but there were these Winklevoss brothers who came up with the idea of a social network, and they told Mark Zuckerberg about their idea because they wanted him to work on the development of their app. Mark Zuckerberg, just gave them the impression that he was working on the software, but he decided to actually build his own social network, which he called Facebook. So, and there was a lawsuit later between the Winklevoss brothers and Facebook. They settled it. I think they had to pay $60 million or something. But you can just imagine that was the damages, like despite not having paperwork. So if they had concrete IP protection, then it would have been even easier to enforce, the infringement of IP. So let's look at the entire life cycle. So right from the time you are doing your research to the time you're able to make money from it, right? So there are different stages in this IP life cycle, and it's very important to begin with the end in mind, right? So if you're, for example, doing some research and you don't have any particular goal in mind, you don't have any objective, right? Apart from maybe just contributing something new or discovering something, right? So then it's very unlikely that the output, the final end result of that research is going to be leading to wealth generation. It may not be successfully commercialized eventually, right? So it this in this life cycle, each step, it's very important that it's performed keeping the end goal in mind. Whatever is your business objective, whatever is your end goal, right? So you link each of these steps to that goal, and each step leads on to the other in a very strategic and systematic way. Only then you will get the final result. So we'll talk about these, but let me just first start by talking about the R&D optimization process, right? And here it's about choosing a topic for research, and I'll talk about it in a little more detail. I have a couple of slides on this. How do you choose a topic for research in such a way that it has got a higher chance of being successfully monetized? Okay, and if you are assuming that you have done some amount of R&D optimization, you have selected a topic, you have done your research, and you've come up with something which is valuable, right? Some IP. Then the next step would be to identify what IP you have and what forms of IP are intellectual property rights you can use to protect that IP. And this is carried out, this is called an IP audit, which is about identifying the IP that you have and also classifying it as protected through patent or design registration or copyright or trademark, right? Or to keep it as a trade secret, which could be a business decision. Okay, so once you've done your R&D and you've done your IP audit, the next step is to then go and protect that IP that you have created and that you have identified and that you have classified, right? So you have to go and register your IP rights in different countries wherever you see the market potential for that. So it's not enough to just register it in, the country where you're located, or where you registered your company. Your market might be elsewhere. So we'll go into it more in detail. Many of the IP rights are not, uh, you know, they're all country specific. They're territorial. So you've got to register your IP rights in each country. So once you've protected your IP, in key markets, that's when you can try to commercialize it. That's when you can make money from, say, one example is licensing, where you earn royalties, you earn passive income. Even if somebody else is actually maybe building the product, manufacturing it, somebody else is marketing it in a different country, they may still pay royalties for each unit that they sell, and you get a percentage of the sales. So licensing is one way to monetize. There are so many other ways you can. So another exercise that you would typically do when you're making, for example, a business plan, right, is to identify your strengths, weaknesses, opportunities, and threats. Now, one component of that could be related to the intellectual property. So when it comes to intellectual property, what are your strengths? So that is if there is some IP that is required for the business, given the nature of the business, right? And that IP is required, and you own that IP, right? That becomes your strength. But if you require certain IP to do your business and somebody, you don't own that business. I mean, you don't own that IP. So then that becomes a weakness for you, right? Because you're dependent on the owners. And an opportunity is that when you look at the industry, you look at that domain, and you uh, see that the industry is heading in a certain direction. So you might, for example, in today's world, the entire world is heading in the direction of AI, right? So there are a lot of opportunities if you use AI in different domains. So if you're able to identify that, okay, that this industry is heading in this direction and people are going to require certain IP to succeed in this industry, then I'm assuming that nobody has gone and created that IP yet, right? And you go ahead and create it and you protect it. So that becomes an opportunity for you, right? To get a important strategic position in that market. And last is that if certain IP is really required to operate in a particular industry, and not only you don't own that IP, but perhaps someone who's your competitor owns that IP, so then they might just come after you and shut you down. So after you spend a lot of time in building your product and raising money and then taking it to international markets and so on, then you get swarmed with legal notices saying that you're infringing someone else's IP. And then you have to, and then the court might issue an injunction saying that this product has to, be taken off from the market immediately. The goods should be confiscated. So just imagine if you have to, put all your goods off from the market after building them and selling them, right? Taking them to the market. So that's a serious threat. And that is why it's very important to be aware of these threats and to make sure that you avoid infringing other people's IP rights. So I was talking about how to identify potential research problems. So of course, there are different ways you can do it. You can talk to potential customers. The most common thing you will hear when you hear entrepreneurs talk about their stories is that they themselves had a certain problem, someone in their family had that problem, and they try to then go about and create a product that would solve that problem, right? But then there are other ways to identify problems as well. So today I'm going to tell you that you can also look at in documents which are published, which are in the public domain, to identify problems for you to work on. So let's say that you are an expert in your own field, which could be, for example, in this slide, I've taken computer vision as an example. But then there are researchers here who have certain area of expertise, right? So let me see if anyone has shared anything that they're working on. So someone's working on micro pumps, right? So that could be an example of an uh, area of research where they have certain expertise. So you could then do a search on patents that are related to micro pumps, right? And when you do this search, it's a pretty broad search, right? So you get a lot of results. So you've got to actually go through those results, and you have to see, okay, within pumps, right? Within that domain, what are the kind of problems people are trying to solve in these patents. So each patent document will typically have a background section, right, where they will talk about the problem that the invention is trying to solve and why is it a relevant problem. So by going through the title, abstract, and the background of those patents, you'll get to know that these are the specific problems related to micropumps that other people are solving. Now, you just think about it. If you have a large company, right, which is an industry leader in that field, and they have filed not just one or two, maybe multiple patents related to solving a certain set of problems, right? So, what does that indicate to you? So large corporations, they're answerable to their shareholders. They have to make money, right? So typically, if a large company is filing patents and they're conducting research, they're building teams to solve those problems. It would typically be because they see the market opportunity by solving those problems. That they think they're pretty sure that they'll be able to if they solve that problem, they'll be able to build a product, and that product has a market, right? Which they will be able to uh, tap into and make money. So they would have invested in market research before putting together a team of people to solve that problem, and also investing money in patenting it, right? So this gives you a clue as to what are the problems that have the potential for commercialization, and then you can focus your research on solving the same problems but in a better way. Now, being a startup or a independent researcher, you have the advantage of agility, that you are not so constrained by the bureaucracy that large companies have and getting so many approvals and so on. Because like in a large company, right, you might want to work on a particular problem, but if it is not uh, approved, it's not aligned with what the company has asked you to work on, then you will not be given that approval to work on that, right? So as a startup or as a researcher, you can quickly spend your time, your resources. You can hire young people who are passionate, who are hardworking, and you can come up with solutions. And then, if you're able to patent those solutions, which are improvements over the existing approaches, then you're creating a valuable asset, and you can actually approach the same companies to either license your patent or even to acquire your patent or to acquire your company itself, right? So a lot of startups, they have this doubt as to what could be a potential exit strategy for the investors, right? Because investors are looking to exit at some point. So, one of the common ways of investors to get an exit from a startup, particularly a technology startup, right, would be through an acquisition. So, because it's quite rare that really deep technology or innovative technology startups are actually listed in the in a Nasdaq or something like that. So that tends to happen, but it's relatively most of the exits happen in through mergers and acquisitions. Okay. So
Arjun, before we move to the next slide, we have a couple of questions, interesting ones. Can we take them?
oh yeah, sure.
Yeah. So we have one from Neha
So
where
let me
she's
look at
asking,
the
yeah, please, you can do that.
yeah, you go ahead. You can tell me like which questions. Yeah. Can we patent the building structure?
Mhm.
Um, So, that structure, if it is functional in nature, right, and it solves certain technical. So, let me come to this. So, actually, I'll be talking about the requirements to get a patent, and that's when, once you understand the requirements, I can answer this question better. But the answer is, it is possible, right, provided there is some functionality associated with it. It could be the materials that you're using, it could be due to that structure, you're able to make it more stable or more resistant to weather, or make it you're able to reduce the temperature inside or things like that. So functional aspects can be patented. Yeah, is there any other question you'd like me to take now?
Yeah, we have how do we protect our patent services? One. from Mayur.
How do you protect services, right? So, I mean, again, it's a very broad question, so it depends on what the service is. So typically, patents protect uh, products, but they also protect processes. So if your service is a process and it is implemented using some technology and it satisfies the other requirements, I'll talk about it, novelty and inventive step, then it can be patented.
Arjun, may I just in continuation to what you just said? So when I was saying services, I was referring to something which is general in terms of services, what others also offer, like an online marketplace. So if I have an online marketplace today and I'm trying to offer some services on that, it's obviously a aggregator role of buying and selling of products and services. So how do you safeguard your interests out here?
Right. So, see, like the basic principle of intellectual property rights, right, is that they are given to reward or to protect inventors or authors or people who are creative, who have contributed something original, something which is unique, right? So if you're doing something which is already existing, which is not original, which is not unique, then intellectual property rights is not the way to protect it because you should have created something in order to protect it. But it also gives you a clue. Then wherever you can create something, innovative or creative, you can protect it. So you can create a barrier to entry through the content that you have, for example, like the whatever you put up online in the forms of written content, in the forms of videos, sound recording, all of that that can be protected through copyrights. You can protect yourself through, say, of course, you have online marketplaces, but many of them leverage technology. A lot of them they use image recognition, they use AI, right? So I'll just give you an example, right? So then you could come up with a unique recommendation engine. I'm not saying that there are already a lot of recommendation engines, so it's very crowded already. But then it's not so easy. But if you're able to come up with something unique there, you could possibly patent it, right? So let's look at, for example, a startup that I know of, which is using generative AI to create synthetic images of humans, right? So, and that is used to replace, photographs of products or photographs of models wearing the products, right, in the marketplace,
Okay,
online. So that is something that you could patent, right? So
fair enough.
what I'm saying is that you've got to do some research and development to patent it. If you got to do something creative to copyright it, or you can build a brand, right? So Mayur, for example, your marketplace, you can communicate something that is valuable to your users, to your buyers and sellers, and so on.
Right.
And what people start associating with your marketplace, you can, communicate it through a product name, a company name, a logo, and so on, and you can register the trademarks for that. Uh, so these are some ways in which you can protect yourself uh, through IPR. Yeah.
Okay, thanks.
Sure. So this session is like a beginning for many entrepreneurs. It's like an eye opener. So some of you may already have some IP and you just want to figure out how to protect it, but some others may not have something yet. But this at least tells you that if you work in a certain direction, then you can create IP and you can also protect it. And that's how you can differentiate yourself from your competitors, and that's how you can build valuable assets. Yeah. So, I mean, I see a question on patenting processes. The answer is yes. Yes, you can patent processes, but we'll come into again, the requirements are similar to products. They have to be new and they have to be inventive, right? So, shall I move on now? I'll come back to the questions.
Sure, Vipin, yeah.
Okay, so I guess many of you entrepreneurs would have watched Shark Tank, right? So this image is from the US Shark Tank. So this guy Robert, right? So I just took a screen grab of the screen. What happened really was this entrepreneur was pitching to the sharks, and the sharks asked him, "Oh, is your idea patented? Is your invention patented?" Right? And the entrepreneur said, "No." And that was the expression on Robert's face. I just grabbed the screen. So as you can see that, investors are pretty shocked when entrepreneurs come to pitch in public forums and they've not even bothered to protect their invention, because it's the moment somebody sees it, they're going to copy it, right? And there's nothing you can do to stop them. So which means that you lose your competitive advantage. And a lot of times, investors ask this question, what is your moat, right? And if you don't have any proper answer, like I saw, for example, there was this Shark Tank episode where this herbal product company went and pitched, and the sharks asked them like, what is your IP? What is your moat? And they said, we have this, composition, this formula, but then it's already put on the label. So everybody knows what you're doing. Yeah, I mean, you might have some certain variations which are trade secrets, right? But if somebody puts a team of scientists onto it, they'll figure it out. So the only way you can stop them is by patenting it before you go to the public. Okay, so let's come without further, delay. What is a patent, right? It's a grant of an exclusive right. It's given for an invention, which is a new product or a process, and it's an exclusive right. So an exclusive right is to stop other people from making, using, or selling the invention. A patent is granted only for a limited period of time, but it's a significant amount of time. It's 20 years. So in 20 years, if you have the exclusive rights, you can exploit it very significantly. You can make a lot of money from it. So the patent rights are given by the government of a particular country where you apply for the patent, and they're given to the applicant, the person who's applying for the patent, right? And they give it in exchange for disclosure. So when you file a patent application, you have to describe how to make and use your invention so that people can learn how to make it without undue experimentation. Okay, so basically the patent is, you understood, it's for a limited period of time, it's given by a country, it's exclusive rights, it's given for an invention, okay, and in exchange for disclosure. Okay, now we'll come to the question, what is an invention? Even before we ask what is a patent, how can you patent something, what is an invention, right? So if you have some product or process which addresses a need that has been there for a long time, which solves the problem in a new way, right? Which is, say, if you have a product, it's altering one of the components. If you have a process, you're replacing one step with some other step, right? And these changes that you're making, is it conventional in that field or is it unconventional? So if it's unconventional, it's more likely to be patentable. Is it an improvement? It's improving some technical features, some performance parameters, speed, accuracy, and so on. Is it producing certain advantages? Predominantly technical, but it could also be economical advantages, right? And it is something that is commercially valuable. And if you are through your product or your process, you will be able to get an edge over your competitors. So the answer to these questions is yes, then there's a pretty good chance that you might have something which is an invention. So the next question is, okay, I have an invention. What are the requirements to patent it, right? So first thing is subject matter eligibility. So there are certain types of domains where there are restrictions on patenting them for legal, I mean, for statutory reasons, for legal reasons, right? So that varies from country to country. Uh, so we'll talk about it a little bit more later this time. So, but other than that, the most common criteria are novelty, non-obviousness, and utility. So the invention, the product or process as a whole should have at least one component or one step which is not there anywhere in the public domain, like which is not disclosed through a publication or a patent and so on, right? And by combining existing sources of information, it should not be obvious. Your invention, your product or process should not be obvious to a person in the same field, right? So that is non-obviousness. And utility means it should be capable of industrial application. So before I go further, I just wanted to check with you, Rupali, like how much time do we have?
We are 4 now. We might like pull it to another 5-10 minutes. Should be fine. Yeah.
Okay, so I'll quickly cover some key concepts and then we'll wind up. Okay, I can also take some questions. Okay, so
Yeah.
basically, this is the public domain information. There's a term for it. It's called prior art. it includes journal publications, patent documents which are published, and whatever is already in use in the market. So this obviousness is evaluated by a person having average skill in the same field. So we're not talking about a genius, we're talking about an average person, but who has access to the relevant information, the prior art. Okay. So basically, one patent is given for one invention, which is a single solution to a single problem. Many companies, they have this question, should I patent something or should I keep it as a trade secret? There are pros and cons. Like if you keep it as a trade secret, the moment it leaks, everybody knows, you can't stop it, right? So even if somebody violated your NDA, you can sue that person, but then the damage is already done. But if you have a patent, then you can stop them. But even patents have to be prepared in such a way that it's difficult for other people to reverse engineer the patents. So that's why patent preparation is a skill. It's not something that's so easy to do, because you got to think of all different ways people will copy it and you have to cover it in the patent. So one common question people ask me is like, I'm a Indian resident, or I have incorporated my company in India. Can I patent it in the US, or can I patent it in Dubai or Singapore? Yes, you can. Any company, any individual, anywhere in the world can patent anywhere else in any other country. There's no such restriction. Given that there are no restrictions, where would you patent? You will protect it where there's a market for it, where there's value for it, right? But you've got to keep in mind that patents are country specific. So you've got to uh, know the laws in each country and have the right people who can help you to get patents in those countries. Why would any company, startup, or apply for patents? Like I said, they transform your intellectual effort into wealth, into assets, right? They increase the company's valuation. So company A and company B, right? Company A has protected their patents, their trademarks, their copyrights, their designs, and company B has not done that. The valuation of company A will be higher vis-a-vis company B, assuming other factors are similar. So, and that is a way for a company which has protected its IP to preserve their competitive advantage over an extended period. So, for example, patents are valid for 20 years. Trademarks are valid in perpetuity. As long as you renew your trademark every 10 years, you own the trademark. Coca-Cola still owns the trademark, right? So, copyright 60 years after death of author. So, it's sustainable competitive advantage, right? And see, if what is the best way for you to brand your company or your startup as an innovative company? By getting IP rights. So that's when people believe that they actually have something innovative. Otherwise, everybody says it's a one of a kind, it's innovative, right? How do we believe you? Show me the proof. So if you've got, for example, a patent registered on it, then there is some validation that there is innovation. And when you have a culture in your company of encouraging people to innovate and also patent, then people who are very smart, who are creative, who are intelligent are more likely to continue to work for your company. So, how did a lot of the startups attract high quality talent? Is by encouraging their team members to come up with innovative ideas and reward and recognize them. So that's how you are able to also retain good people. um, Otherwise, like everybody, tomorrow some other company will get more funds and they'll give a better salary. You can't retain people. There are companies like, for example, Texas Instruments, GE. They have retained the best engineers and scientists by creating this kind of culture, right? Okay, so I think I've covered a lot of things. Okay, we came up with the slogan at Metayage, which is a patent competitors envy, inventors pride. So it's a matter of great pride, okay, for you as an inventor or as a startup, as a company to have a patent, because you know anybody can buy a fancy asset, but in order to create, I mean, or to have IP, you should have created something unique. You should have contributed something to the world, and that is a matter of pride, because not anyone and everyone can do it. Okay, so I'm going to stop here, and I'll take some more questions. If still some questions are not clear, I'll quickly try to answer. So before showing a software on a website for demos should be copyrighted. Uh, so copyright registration is not mandatory, like I said, but if you want to sue somebody for infringement, before that you should register it, right? So copyright is not so urgent. But then if you have a functionality in your software which you want to patent, then you should apply for a patent, at least a provisional patent application before you demo it, right? So hope I answered that question. And then we have if company C is building a hardware product which is designed by company D and manufactured by company M, then should company C, which is building the hardware product, should we go for design registration? So the hardware product, see, design registration covers only the look and feel, right? So hardware product, unless, like for example, it's a consumer product, right, where aesthetics matters, then you can register the design. But if it's more of a functional aspect, then you should protect it through a patent rights. So after company D completes the work, how do you avoid leaking it to other vendors? Of course, you can have non-disclosure agreements with all the other parties who you're disclosing it. Yeah, but patents is the best way. I would say file a patent application even before you disclose it to anybody else. The company which designed it, which is company D, should file a patent application before they enter into the manufacturing contract. Yeah. So like I said, processes can be patented, even software inventions can be patented, provided they contribute something to a technology or a technical field. So then, if you're able to convince the patent office of that, you can get a patent for your process as well. I actually included some case studies in my slides. Is it important to file a patent before investor pitch? I would say it's recommended to at least file your patent application, right? Because then you will get the confidence that whatever you're talking about is protected, right? So you want to be able to share information with your investors so that you build trust. And if you've already filed a patent application, you will feel more confident and secure before sharing information with others. So you're saying patents take a lot of time to get approved. So basically, I mean, that has improved a lot. So, like for example, in India, you can file a request for expedited examination as a startup, and you can get a patent registered within about a year, say 1 to 1.5 years. So that's not a very long time, right? But then, if you want to know how you can protect your invention, you just file a patent application. You say patent pending, so you are in some sense protected because if somebody files a patent application after you, they can't get their patent. Their patent will be rejected because you have filed before them. So that is a form of protection until your patent is registered. Once it's registered, you can sue people for infringement. I mean, I've not heard of many startups who start filing lawsuits within 1 year of their incorporation, right? So you can get your patent issued and then you can look at enforcing it. The more important reason to file a patent is not just to go to court and start suing people, but it is to protect whatever value you have created for your company and for your investors and all stakeholders. I didn't understand the question about journal publications. Because I don't know if journal publications have to be registered and so on. But I told you about patents; they need to be registered in different countries. Where do you search, right? So of course you can search on online on search engines, but you can also search patent databases. So there's one search engine called Google Patents, which is patents.google.com. So you can type patents.google.com and search on that database. You can search on freepatentsonline.com, right? So you can do a keyword search and you can find existing patents. So when a provisional patent application is filed, is it available in the public domain? No. A provisional patent application is kept secret. So until you file a complete application and also it takes some time for it to get published, only then it's available for others to access. Till the time it is kept secret. Okay, so I think I've answered most of the questions. All right. Um, thank you very much.
Thank you, Arjun. Are there more questions? You can unmute and we can take it up. We can give it like a minute more.
Yeah, Arjun, hello. Can you hear me?
Yes.
Yes.
Yeah,
Yeah.
so my question is, I think like I'm running a startup, focusing on the demented segment, the dementia segment. We, as a startup, we developed a 6-bucket non-pharmacological approach for helping the patients to improve their cognitive stimulation. That is our invention. Okay, so in order to patent, our invention or our 6-bucket approach, what should we do? Like, especially in healthcare segment, is there any specific advice you would like to give it to me?
Yeah, I can have a more detailed conversation with you because perhaps there's some more information which you may not be feeling comfortable sharing on this open forum, right?
Okay.
So, because we need to understand it more in detail to advise you whether you can protect it through patent or trade secret or what is it that you can copyright and so on. You can actually look at all these three options: patent, trade secret, as well as copyright. But I mean, to the extent that your process is implemented using some technology and maybe there is some monitoring happening there, right? So that part can be easily patented. But you've got to keep in mind when it comes to these kind of treatment processes and diagnosis processes, the process as such of treatment or diagnosis is not patentable in India. So that's why it makes these kind of inventions more challenging to patent. But we've done it a lot. Like for example, we work with a company called Brainsight. So they related to neuro related AI and tech. So we've got patents for them. We've got patents for companies which are doing breast cancer screening. There are my health analytics, right? So there it's more of the technology that is patented, not the method of in which a medical professional would diagnose a patient or treat the patient, right? That part may not be patentable because nobody wants to stop medical professionals from doing their job, right? So that's the reason.
Okay, so in order to discuss in detail, like what should be the next step? Probably like would you share your contact number or email ID or something?
Yeah, sure. You can send us a mail, to ip@myipstrategy.com. We can pick it up.
So will you text your email ID here?
Yeah, it's on the chat, ip@myipstrategy.com.
Okay. Thank you. Thank you.
Hello.
Yes.
Can you hear me?
Yeah, I can hear you.
Hi, Arjun. My question is, do you have to register your copyright in different countries so that you can value it and get IP valuation and be able to borrow money against your IPS collateral?
Yeah, so I mean, with reference to what kind of IP are you talking about?
So my IP is a math IP in math.
Okay, like a pure mathematical algorithm, right, is not patentable. And
not algorithm, it's a math formula.
Yeah, yes, formulas, equations, mathematical concepts. It's not patentable on its own. But for example, if you apply the sorry,
it's a copyright.
See, copyright doesn't protect anything that has a result or a functionality, right? The copyright only protects creative expression. So if you write a paper on your math, it can be copyrighted. Means you can stop other people from publishing the paper, right? Or you create some content based on that. That can be copyrighted. So pure math cannot be protected through patents or copyrights. At max, it can be a trade secret. So before you disclose it to another party, you can enter into an agreement with them. So it will be treated as know-how. It can be licensed. Even know-how can be licensed.
Yes. So like my question is, do we have to register it in different countries to borrow money with IPS collateral?
So, I mean, when it comes to, for example, patents, right, or registration is required, right? But trade secrets, there's no registration. It's just about keeping it as a secret. So, I think that would be a discussion. I would need to know more about it. It's better. See, we for example, we sign non-disclosure agreements with people even before engaging with them. So then that way you might feel a little more comfortable talking about it, and we'll be able to give you advice. You can write an email to me if you have any questions.
Sure.
Okay. Yeah, so we're running out of time. I think we'll take a quick minute to wind up the session. So for any more questions, right, either you can drop an email to Arjun. His email is in the chat box, or you can drop an email to me and I'll pass it on to Arjun. I'm just dropping my email as well. Yeah. And we'll mostly be sharing the recording after this, so you guys can refer it. And if there are any questions, please come back. Please drop an email. Feel free to reach out to us anytime. Thank you so much for attending the session. Thank you so much, Arjun, for the time. And thank you, John, for the collaboration on this event. So we have John from IMK Live, Arjun, with whom we actually collaborated for doing this event. Yeah. Let's stay in touch, and we look forward for more sessions ahead. Thank you.
Thank you very much, Rupali, and thanks, John. So there was one more question about software architecture being patentable. The answer is yes, you can patent software architecture, right? Again, it has to satisfy those criteria. Happy to get on a conversation with you if you want to explore that further. Thanks very much, and yeah, have a great evening. See you. Bye.
Thank you. Bye, everyone.